Hello everyone, my name is David Williams. Tonight we're going to talk about trust administration fundamentals. It's actually going to be a little broader than trust administration. I told Alan it's what we called in law school dead people and their things. That's what we're going to talk about tonight. Why are we here? It's not for a sales pitch. It is to discuss what do we do when a loved one dies. I want to help you with that. We're going to talk about basically three areas. First, we're going to talk about when is it necessary to file a probate and what assets are transferred in a probate. What are the steps in administering a trust and what assets are administered through a trust, and how are assets transferred through joint ownership or a beneficiary designation. For those of you that are watching online, if you have questions, just type those questions into the chat bar and Dallin will raise his hand and ask those questions for me. For those of you who are here, if you have questions, just raise your hand or just pipe up. We'll try and address them. My name is David Williams. I've been practicing law for a little over 30 years, and a big part of my practice includes estate planning, trust administration, and probate. I went to law school at BYU, and before that, as I was discussing with Dallin, I got a degree in animal science from Utah State University. Hopefully, when we're done tonight, you'll know a little bit about how to administer an estate, and you'll know when it would be good to call a professional and ask for help. All right, let's first talk about the probate process. As we talk about these three kind of categories: probate, trust administration, non-probate transfers, it is not so much the person who died as the assets that determine which process you have to use. And it is the ownership of the assets, the form of ownership of the assets, that determine what process you have to use. So, when would you have to file a probate, or when would you have to administer assets through a probate? If the person who died owned assets in their individual name, then you may have to go through a probate process to transfer those assets to the next generation, to their heirs or to their devisees. A person may have a will and they may not have a will. But whether or not they have a will, if they owned assets in their individual name, so if the title on the deed to land says David Williams, then you'll have to file a probate in order to administer those assets. The first step in a probate is the appointment of a personal representative. Probate is a court action. You have to file an application with the court and ask a judge to appoint the personal representative. If the person who died left a will, usually the will nominate somebody to be the personal representative. If they didn't leave a will, then there's a state statute that says here's the order of priority for appointment as a personal representative. So the person who has the highest priority to be appointed as personal representative is the person nominated in the will. It's I think a fairly common misconception that people think I am the personal representative because it says in the will that I should be the personal representative. Even if the will says you should be the personal representative, you still have to go to court and have a judge appoint you as personal representative. The second priority is the surviving spouse, if there is a surviving spouse. The third priority is adult children of the decedent. And then anyone who is an heir, and we'll get to that. The second point then is who gets assets. Who are the assets distributed to? And the assets are distributed, if there is a will, then the assets are distributed to whoever is named as devisees in the will. If there's not a will, then essentially the state legislature has written a will for you. And that's called intestacy, or intestate distribution. Basically what the intestate statute says is everything goes to the surviving spouse unless the person who died had children who aren't children of the surviving spouse. So if there are children from a previous marriage, then the surviving spouse gets $75,000 plus half, and the children get the other half. If there is no surviving spouse, then the assets are divided among the children in equal shares. If there are no children, it goes to the grandchildren. If there are no descendants, it goes to the parents. And if there are no surviving parents, it goes to the descendants of the parents. So brothers and sisters, nieces and nephews. So there's a pretty extensive list of how property is distributed in intestacy. Of course, if you write a will, you can then direct who you want to receive your property. And basically, you can give your property to whoever you want to give it to, and you can exclude whoever you want to exclude, except you can't disinherit your spouse without his or her permission. So what I mean by that is that under the law, the spouse can elect to take what he receives in the will, or he can choose instead to take the spouse's elective share, which is approximately 1/3 of the estate. When I said you can't disinherit your spouse without your spouse's permission, most often that permission is given in a prenuptial agreement. So people who have been married before often will, and even if they haven't been married before, they often will have a prenuptial agreement. And in the prenuptial agreement, the spouses can waive the right to inherit. So in a prenuptial agreement, often they will waive the right to inherit so that the property can go otherwise. So that's a will versus intestacy. The process of probate is that first the person gets appointed as personal representative of the estate. Second, they take possession of the assets. That, you go to the bank and you give them the letters of administration that say, I've been appointed personal representative. You then liquidate assets as necessary, so sell the house, sell the land, sell the cars, unless there's instructions to make distributions of specific assets. You have to pay creditors first, Creditors get paid before property gets distributed. And then once you have paid creditors, you distribute the assets, either according to the terms of the will, if you're working under a will, or according to the intestacy statute if you're working under the intestacy statute. So that's the basic process of probate. Well, I would say that you have to file a probate if the decedent, if the person who died, owned land in their individual name. You have to file a probate if the assets that are in the individual person's name exceed $100,000. But always if there's land, even if the value of the land is less than $100,000, you have to file a probate, because the only way to transfer land or other titled assets, the only way that you can transfer land is by having a personal representative appointed. And you have to file a probate within 3 years of the date of death, or you can't file a probate. So we have situations where, and most often it's because grandma or grandpa conveyed land, but there was a mistake in the legal description. So we sometimes find situations where someone will come to us and say, I have this piece of land, and often it's like a strip of land, and it's in the name of grandpa, and grandpa died 50 years ago, and it's too late to file a probate. What do I do? Then you have to file what's called a petition to determine heirs, which if grandpa died 50 years ago, can be quite complicated, because then you have to find all of grandpa's descendants and figure out who possibly has a claim to that land. So that is probate. Any questions about probate before we move on to trust?
I just have a question. If you weren't going to use an attorney and were going to do probate, or if there was a probate situation, is there a cost to go before the judge?
Yeah, there is. And so there is a filing fee. It's $375. You have to file to pay to file an application. You would have costs. One of the things that you can do, and it depends on the situation, but you can give notice to creditors. If you publish notice to creditors that you have filed a probate, then all creditors' claims are cut off after 90 days. So if there are potential creditors out there and you want to shorten the time for them to make their claim, you publish notice. You've probably seen those notices in the newspaper, and there is a cost associated with that. Depends on the newspaper, but there's a cost of publishing creditors or notice. There's the cost of recording deeds of distribution, those kind of things. So there are some costs. You can file a probate on your own. There are forms available on the Utah Court's website. I generally recommend that you not file a probate on your own, just because it's complicated enough that you can make mistakes, and it's generally much better if you hire a professional. If you need to file a probate, it's probably better that you hire an attorney to do that for you. John?
So logistically, and never having been through probate, that is just simply usually an attorney, or I guess if you try on your own, and you contact the courts and say, you know, we would like to come before the judge. I'm not sure logistically.
Yeah. So logistically, you file what is called an application for probate, or a petition to probate a will and appoint a personal representative. And it's a document that basically says so-and-so died on this date, he left a will, or he didn't leave a will. Here are the people who are entitled to notice of the petition, and we request that I be appointed personal representative, or that the will be probated, determined to be valid and be probated, and that I be appointed personal representative. Then you either have to send notice to all of the heirs and devisees, or you have to get waivers of notice from all of the heirs and devisees and file those with the court. If you file waivers of notice, then the court will issue the order appointing you as personal representative within a matter of a few days. If you don't get waivers of notice, then you have to send notice, and the court schedules a hearing, and you have to appear before the judge at a hearing, and if there aren't any objections, then they'll appoint the personal representative. If there are objections, then you have to go to mediation, and if you can't get it resolved at mediation, you have to litigate over who has priority to be appointed as personal representative.
So you could probate without going in front of a judge, technically?
Yeah, so in an uncontested probate, basically we file the documents, meaning the application and the waivers from all of the appropriate people, and the court will simply issue the order without having an actual court appearance. But if you don't get waivers, then you have to have a court appearance. Okay? Other questions? All right. If the assets are owned by a trust, so if the deed says Jeff Bush, trustee of the Bush Family Trust, then that particular asset doesn't have to be, does not have to be administered through the probate process. One of the advantages of a trust, and you have to set up the trust ahead of time, but one of the advantages of the trust is that assets that are owned in trust don't have to go through probate. And that tends to save some money, it saves time, and perhaps most importantly, it maintains privacy. Probate is a public process. Anybody can go to the courthouse and look at the application you filed for probate. Trust administration is a private process. In trust administration, usually in the trust agreement that grandma or grandpa set up before they died, it will say, here are the trustees of the trust while we're alive, and when we die, then it names successor trustees. Those successor trustees can simply step in and do whatever grandma and grandpa did when they were the trustees. So there doesn't have to be a court appointment. But the steps are essentially the same other than the court appointment, and that is the successor trustee notifies the beneficiaries of the trust that he is the successor trustee. He takes an inventory of the trust assets and provides that inventory to the beneficiaries of the trust. He takes, those probably should be inverted, probably you should take possession of the assets first, then provide an inventory, then pay creditors. Now in a trust, if there are creditors of the trust itself, and usually those creditors would be secured creditors, like a mortgage company that has a lien against a piece of property that's owned by the trust. But oftentimes the trust agreement will say, use my trust assets to pay any personal creditors that I have. That's not always the case, but if but you can pay creditors, and then you distribute the assets to the beneficiaries by deed, or you sell the assets and distribute the money to the beneficiaries. Again, the trust administration process tends to be smoother, but there can be disputes whether you're in probate or whether you're administering assets through a trust. If somebody objects to what you're doing or thinks that you're doing it wrong, they can challenge the administration of a trust just like they could challenge the administration of probate in a lawsuit. So trust administration doesn't always go without a hitch. And we as lawyers tend to see the ones that don't go without a hitch where there's problems. So the trust designates who the beneficiaries are. And the trust can be, sometimes it's complicated and sometimes it's simple. Sometimes it'll hold assets in trust for generations. And so a trustee who's administering a trust could be administering those assets for years and years, distributing income, investing principal, all of that. It just depends on how the trust is written. So, questions about trust administration? Again, the only assets that are administered in a trust are those assets that are owned by a trust. Sometimes those assets are transferred, hopefully those assets are transferred during the lifetime of the grantor or the person who created the transfer, or who created the trust. Sometimes those assets come from a probate estate, like if the will says my assets go to my trust. But in the trust, you administer the assets that are owned by the trust. Sometimes assets don't have to go through probate or be administered in a trust. One example of that is jointly owned property. That is, I'm talking in this first category about real property, land, that says on the deed, joint tenants with right of survivorship. So for example, my wife and I own our house as joint tenants with right of survivorship. If I died, my wife would own the house. She doesn't have to record a deed. She doesn't have to file anything with the recorder. She doesn't have to go through the probate process. She doesn't have to go through the trust administration process. She owns the house, which is really convenient if you're husband and wife, but can lead to problems if you own property as joint tenants with somebody other than your spouse. Do you have a question?
Yeah, what if it's just husband and wife? What if the deed doesn't say with right of survivorship?
That's an interesting question, because what the statute says is if the deed says husband and wife, it's treated as joint tenancy property. It's treated as if it had a right of survivorship. If the deed says joint tenants, it's treated as having a right of survivorship. If the deed says joint tenants as joint tenants with right of survivorship, it's treated as having a right of survivorship. If the deed to me and my wife said to David and Susie, but didn't say husband and wife, and didn't say joint tenants, it would be treated as tenants in common with no right of survivorship. So if property is owned as tenants in common, which is common ownership without a right of survivorship, then each of the owner's shares have to go through probate to go to their heirs. So if I owned property with John as tenants in common, no right of survivorship, when I die, my half goes to my heirs. And when John dies, his half goes to his heirs. but it would have to go through the probate process to get transferred to my heirs. Does that make sense? Okay. You've probably seen on car titles, it will say David and Susie, David or Susie. Those are treated as having a right of survivorship. Joint bank accounts. Now, joint bank accounts, you can get into, not into trouble, but you might have an unexpected result if you name someone, if you give someone signing authority on your bank account. So if I have a bank account and I give someone else signing authority, even if I don't make them a, quote, joint owner of the account, then if there is more than one signer on the account, then during the lifetime of those signers, the money in the account is treated as being owned in proportion to the net contributions of the owners. So if there's a bank account and I'm the only one that puts money into the bank account, then as long as I'm alive, it's treated as my money. And when where that becomes important is when creditors try to get the money. So grandma has a bank account. She's the only one that puts money in the bank account. She has her children as signers on the account for convenience. Sometimes the creditor of one of those children will try to get the money in the bank account. As long as grandma's still alive, it's her money, right? And the creditors of the children can't get at it. Here's where people get into trouble. They put one of their adult children as a co-signer or as a signer on the account for convenience. And when they die, the money in that account belongs to the signer to the exclusion of the estate. So, if I have a will that says all of my property gets divided among my children in equal shares, and I have a bank account that is in my name, and I have one of my children as a signer on that account, when I die, the money in the bank account belongs to one child. It doesn't get administered through the will or through the probate. So that might be good because you avoid probate. It might be bad because that child might decide to keep all the money and not share with his brothers and sisters. So that's joint accounts. Pay-on-death beneficiaries. The most common example of a pay-on-death beneficiary is a life insurance policy. When I buy a life insurance policy, I designate this is the person that gets this money when I die. And that person gets the money by matter of contract. The life insurance company pays the policy amount to the beneficiary. It doesn't have to go through probate. It doesn't go through trust administration. It's simply paid to the POD, the pay-on-death beneficiary. You can designate pay-on-death beneficiaries of bank accounts if you want to. And in that case, the money would be paid to the pay-on-death beneficiary. I often suggest that people use pay-on-death beneficiaries instead of signers on the account if they want their kids to get the money, because if it's a pay-on-death beneficiary, then there's no chance that the kids' creditors can get at the money. So it's better protected during my lifetime. Another way that when probate is not necessary is what's called a small estate affidavit. If the entire estate subject to administration is less than $100,000 and does not include any real property, then you can transfer the assets by a small estate affidavit. A small estate affidavit is a piece of paper that says, so-and-so died, I'm the successor to his estate, I want the money in this bank account. And as long as there's less than $100,000, you take a small estate affidavit to the bank, they'll give you the money. You can transfer title to up to 4 automobiles using a small estate affidavit, even if the automobiles are worth in total more than $100,000. So you can have, you could have a very large estate, but still use a small estate affidavit to transfer title to motor vehicles. So, my clients, we use small estate affidavits to transfer title to motor vehicles, to access bank accounts, to access investment accounts, a variety of kinds of assets. You can use a small estate affidavit.
And you said they take that to the bank?
Yeah, if what you're trying to get is the money in a bank account.
So what if this person had 4 accounts with $50,000 in them at different places? That's more than $100,000 if I did the math right.
It is. But this method relies on the person submitting the affidavit telling the truth,
Okay, perfect.
right? So if you say the total estate subject to administration is less than $100,000, and you sign that affidavit under penalty of perjury, which you do, and if it turns out that there was more than $100,000 and somebody challenges you, you could get in trouble. I haven't seen any disputes over small estate, well, no, I've got one dispute over a small estate affidavit. It's a case that JD is handling right now. Dad died, and he left a will. Well, I can't remember if he left a will, but he had 2 adult children who, under the law, are supposed to inherit from him. He had a couple of cars, a Jeep and another car, and when he died, his sister took a small estate affidavit to the Department of Motor Vehicles and said, I am the successor to the estate, change title to these automobiles to my name. And the Department of Motor Vehicles did, because that's what they're supposed to do. And now, through our office, we have sued the sister to recover those automobiles because legally she shouldn't own them. His children should own them.
Because this child probated and became personal representative.
Right. Yeah, and was in the process of doing what she was supposed to do.
Her letters.
And discovered that the aunt had gone and stolen the cars, basically. Yeah.
So does she just have to pay it back, or will she go to jail?
Well, as far as we're concerned, she'll just have to pay it back. You could, I guess, make a police report, and then the police and the district attorney would decide whether to charge her with a crime. I think it is a crime, but it's not in our control to decide whether she gets charged with the crime. Okay? So, have there been any questions on the chat? Any other questions? That's, in substance, all I have. So, keep in touch. If you have any questions about probate, trust administration, transferring assets, you can give me a call or send me an email at Pearson Butler.
David?
Yeah.